it appears that the CCI was dealing with R2's representation for contravention of Section 4. And after going through the same, has formed an opinion that there exists a prima facie case against the petitioner. It is pertinent to note that the earlier representation made by JSW, also not a paint manufacturer, in 2019 relating to violation of same sections. The CCI directed investigation by the DG in January 20 and later on received the DG's report on 8th of September 22, dismissed the complaints as there was no contravention. It is thus evident from the aforesaid the sections, the R filed complaint sections involved were not the same. Apart from the same, what is reflected from the impugned order dated 1st July 25 is that primary reason for dismissal of JSW's representation, that is the earlier one, after receipt of DG's report, was that there is no adequate material supporting the representation made by JSW. So this is the finding of the DG. That's why I reject it. It's not that the informant did not give material. The informant gave material. DG commenced investigation at 26-1, spent 2 years, collected material from across the nation, from dealers, authorized, and then came to the... Now, last night, it appeared that Balaji preferred an appeal, etc., which was dismissed. It further appears that appeal is now pending. Be that as it may, it is not as if once a representation is dismissed, no new representation can be entertained based on... This is wrong. The law is you give information and then the DG takes over. It is not like a civil suit that you file a suit and somebody else files a suit. And then
What is the difference, Mr. Singhvi, in that previous complaint?
Yes. Just 2 minutes.
There was one more thing. Only one more factor. Kindly turn to page 32 bottom.
And up till here.
Page 32 bottom. I'm going to read that.
Yeah.
See below bottom. Now he's talking about the new provision 2A. Last 4 lines below to 32. The word expressly used in the report reveals the object of introducing 26-2A to clarify what is already implied in 26-2, and the use of the term enables establishes the intent and object was to expressly introduce 26-2A as an enabling provision. Thus, CCI will be required to deal with the same 26-2A in the order only in cases where it decides to close by acting. What is this? Close by acting under 26-2 or 26-2A. That is, CCI has the view that same or substantially same facts, information, based information under 19 or reference to the government has already been decided. Conversely, where CCI decides not to decides to directly, CCI is not required to give reasons why 26-2A is not applicable. How is this? No, Act doesn't say all this.
It's a threshold jurisdictional issue.
This is threshold.
Of
JSW.
Yes, I'll show you. JSW was saying the same thing. That look.
Oh, he may say same thing, but this may be for different period.
Completely different.
I am a leader in India for 40 years. I am a leader in paints in India for 40 years or 50 years. So JSW came, they are also new entrants in the market. They are into steel, but they have started paints and Berger paints. They have started that. When they came, they attacked us by filing an information that look, Asian Paints is a giant. Because of his dominant position, it is without squeezing the arm and twisting the arm of the dealers by saying, if you take material from somebody else, Asian Paints will stop giving you material. We are giving you incentives. If you deal with them, you won't get incentives. In other words, Asian Paints is abusing its dominant position in the market. That is the case of JSW. Once that information was made, DG was directed to start investigation under 26-1. DG, there's a procedure under the Act. He has to issue public notice, this, that. He invites, objections. He does his own investigation. He becomes like an investigator. He does it himself, then submits a report. He gave a report after 2 years that the claim of JSW is without any material.
For that relevant period when the complaint was made.
Yes, that was 2 years ago.
So if a company, if the DG gives a clean chit to a company,
yes,
for a particular period, doesn't mean that in future if he...
I am not saying no. I am not saying no, but it also doesn't mean, that merely if 2 years have passed, but the allegations are same. Then what meaning will you give to 2A? 2A says if same or similar complaint is made in that market, then
Same and similar means same period.
you know, period will change every month.
No,
It can't be. Sorry.
reply.
Manoj, just one submission, Manoj. Manoj,
Mr. You will.
You know, different period, sorry,
Have an opportunity.
let me answer Justice Vishnu, they're very important. The CCI now does not, my lord, base its decision to commence investigation against me on the period. I can understand an argument that happened 10 years ago, market conditions, that's what your lordship saying. The CCI or the High Court does not base their decisions to hold, my lord, that the period has changed, the situations have changed, the market has changed, the considerations changed. I can understand that, but that is not so. Instead of, my lord, it's like this. You go on, my lord, with a revolving thing. One paint fellow will come for 2 years, investigation will go on for 2 years. It's very detailed investigation. It's not like a suit. That happens, my lord, in 2 years, 3 years it ends. Then in the 4th year, another chap will come. Another 4 years will go by. After this is over, another chap will come. Therefore, to avoid all that, 26(2)(a) came. To give this kind of a reasoning, I mean, this is something, my lord, I submit. Your lordship will decide. It's a new provision. Your lordship will decide what is the meaning. Is it to nip it in the bud or go on allowing? Then you don't. Commencing investigation against me, which I challenge in the High Court. This will not mean now DG will start. DG will take 2 more years. And Lord, I have been given a questionnaire this long. Now start answering. How many dealers? How much do you pay them? What is their incentive? All my market, Lord, information, confidential information is now becomes, that's the problem. Will become, Lord, public. I don't get a hearing in 26 months. A 15-page order is passed. No hearing is given to me. I just sent off a letter that I am told you are looking at something. Please don't do it for this reason, that reason. That is why they are reflected, my lord, in the High Court's order. But 26(1), you don't give me a hearing and you start, my lord, an investigation against me. They say no, under 26(1), no right of hearing is given. Your lordship may see the order of 26(1). A complete detailed order is passed, which damages, my lord, my business, my reputation. You don't give us a hearing because they say, my lord, we don't have any procedure for granting you a hearing. See 183, my lord. See the actual order. Your lordship will find. Turn, my lord, to 183 for 1 second.
183.
183. That's the order impugned in the High Court, my lord. Just have a look.
Yes, please.
And your lordship find the other side is, my lord, a Birla company. It's not a small company saying that we are being squeezed or something. See, my lord, order under 26(1). The informant in the information in the present matter has been filed by Grasim under section 19 against Asian Paints, alleging abuse of dominant position, etc. The informant is a flagship company of Aditya Birla Group. My lord, they are bigger than me. Then OP is stated to be largest public company in paints, that is Asian Paints, established in 1942. Next page. Para 4. These are, my lord, the allegations as to how Asian Paints is abusing its position, offering additional discounts. C2, enforcing exclusivity. 3, reducing credit. 4, enhancing sale limits. 5, reducing customer leads, terminations, etc. Then next, directing dealers to return or not install tinting machines, that is by which you change color, restrain third parties of suppliers from providing, etc., etc. Then this goes on. Now, your lordship will find at page 187. 187. See paragraph 15. Because when I had wrote a letter to them, I told them, please look at the JSW order. The least they could do was not give me a formal hearing, which they don't. Para 15. As major allegations in the present matter are also with respect to decorative paints, market as in the JSW order supra, the commission deems it appropriate to delineate the relevant market in the matter and also the market of manufacture and sale of decorative paints in the organized sector in India. Then it goes on and on. Then your lordship finds. So first you have to determine the market, whether it's India or abroad. Second, you have to determine dominant position, whether I am the greatest person in the market. 188, my lord, para 18. That is the dominant position. In the aforesaid delineated relevant market.
Now
The
here you
commission-
come,
So
that is not.
and so it goes on and on. Now you and,
Dominant position part may not be in dispute.
correct. No, I am
come-
only now see,
Come to
Lord.
this issue, abuse of dominant.
That is 2028.
That you come to this part.
So you are Lord doing this without giving me a hearing. I can understand. This is not Lord a case where you
This is-
granted.
this
It's
is
not a
not-
case of injunction. Lord, I can
Understand, Mr. Rohde, just, Mr. This is not.
now see Lord dominant. Page 191, para 28. Once the OP, that is me, has been found to be in a prima facie dominant position in the market, that is market for manufacture and sale of paints in the organized sector in India, the commission now proceeds to analyze if there is any merit in the allegation of abuse by the informant which may warrant initiating investigation. The informant has made various allegations against the OP. The first among them being that OP is exercising enforcing de facto exclusivity upon deals. I showed you the chart by threatening against stocking informants' paint, like saying if you do business with them, I will not do business with you. Reducing credit limit, revision of service levels with informant, increasing and enhancing the sales target if they are found to be engaging with the informant. Accordingly, recall benefits like foreign travel, reducing customer, so and so, so and so, so and so. Last 3 lines of that parameter, which as per the informant amounts to imposition of unfair and discriminatory conditions upon dealers in sale of paints in contravention section 4. In this regard, the informant is annexed the information and the response dated so and so, third party market survey. Then this goes on and on and on. Then your lordship finds, see my lord 33, para 33 on the next page bottom. From the aforesaid materials placed on record by the informant prima facie appears that many dealers were facing issues with the OP enforcing exclusivity upon them by coercing them against stocking of other manufacturing paints, including informant's paint, by using various methods. In the opinion, such conduct being indulged prima facie amounts to imposition of unfair conditions, etc., etc. All this is without hearing. Then your lordship sees on the next page is in contravention of so and so. 34.
26, then contemplate this. Now. When there is a complaint comes to competition.
Information. It's not.
Information comes to the.
It's called an information. No? It's not a complaint.
Certainly, information which is received. The question is of 26A applicability. It may be relevant for the purpose of argument, but we have to look into so many factors. First is dominant position. Dominant position part, can you dispute?
No.
Yourself is saying, yes, I am the
I'm not disputing.
So you are not disputing.
Yes, sir.
Now they have considered, now looking to this dominant, whether it is a misuse of dominant position or not, that has been dealt with. Now, while dealing with this situation, that misuse of dominant position or not.
But Lord,
Just please,
sorry.
Mr. Rohde, you have said, please.
Sorry.
For a second.
Yes.
Here you again.
Yes.
So now the situation was the court has, this competition commission has considered whether what is the misuse of this dominant position. certain factors have been taken to consideration. You are saying you have not been given an opportunity for
That is
this
one.
information. It is not required to be done under section 26.
So you have required.
Now you are taking a plea, then you have been given an opportunity for the High Court.
I would have-
Just please, you have taken a plea that 26A comes into the play because it may not. So may not issue has been dealt with by saying that the dominant position has been misused.
Lord, the
So
same,
now then in that situation, this will not come into the rescue.
Lord, it
That
was
you
the
cannot
same
say
argument.
26A.
It was the same argument earlier that you have misused your dominant position by being the boss. It's the same thing. Which means 90.
And everything you rely on JSF, but for determining abuse, you're not even referred to it.
Lord, may I, sorry.
Karnataka. This is not a right, left, and center. I could. It's ridiculous. I won't hear it. Run out of time. Okay.
May I put it another way, Lord? For dominant and market, they rely on the JSW order that you are the leader and the market is India. They rely on it. But when it comes to abuse, their abuse was argued and rejected. The abuse is for abuse, you don't go below there. It's the same.
Bhoti sir, always of 26A intent cannot be that once a complaint has been lodged by anybody,
Yeah.
then thereafter no complaint can be entertained.
I am not saying that. I'm never going to argue that.
Now,
I am saying it is akin to a rule of res judicata that if somebody has come, a competitor to me, it's only by competitors. If one competitor comes and says A, B, C, D, for which the DG conducts an investigation and says A, B, C, D is not made up, I'm not going to detail, and the information is rejected. The next day, another competitor comes and again says A, B, C, D, same. For those below 26, 2A has been moved, that if you find on this chart, then you must dip it
this
in the.
can't be an intent of 26(2)A. You kindly see.
Yes,
The commission may not inquire.
yes,
May not inquire.
yeah. Correct.
Into agreement referred to in section 3.
Yes. Yes.
Agreement referred into section 3.
Correct.
Or conduct of an enterprises
Under 4.
or group under section 4.
Correct.
So, an enterprises or group of that.
Yes.
Section
Correct. Absolutely correct.
It is same or substantially the same facts issue raised.
Right. I am saying.
So, no, sir,
Yes.
this is not always, no, this we cannot interpret in this way that once a complaint has been decided, it will not be treated with.
I'll only add one thing. Our case today is
Let
not.
Mr. Rohit
Wait,
sir
wait,
complete, then
wait,
Mr.
wait,
calls are
very,
after.
very,
Yes, please.
very-
I am saying the error is in misconstruing 2A. I would submit, Milan, a case of 2A has to be authoritatively decided by the Supreme Court. It has just come in 23. The idea is to bring a rule akin to below res judicata.
This is not appropriate case. We see the findings. It is
Obviously.
recorded. This is not appropriate. We can decide this, not a problem. You see the finding as recorded
Yes.
in this case.
Finding is,
Kindly see this here in this case.
yeah. So, Milord, come back to the order of at 183.
Yes.
So ultimately,
We
Milord,
come to para 95, 195. Further, some
Yeah.
of the employees, 195 page number,
just may I show 193 for a minute? 193.
194 last para. In this
No,
regard,
I wanted to
in
show
the third party market survey place, or
so
record by the informant, some dealers have stated in the case that they do not sell their other brands. We can understand if you have filed that what by the order of the JSW.
Yeah.
What by the order of the JSW?
I filed, Milord.
Where is that?
It was
And
there
compare this.
before the High Court also.
Please show that.
Before
how
you, yes.
the same material was there, sir.
Milord, it can't be identical. The words are similar. The words are similar. It can't be identical.
We are not saying identical,
All
sir,
right.
we are same material.
Right. Put it down, my lord, have a look
We are
at.
also saying same, sir.
Correct. Page 99,
Page 99, sir.
my lord. Page 99,
99,
yes. This is, my lord, the order of JSW.
yes.
Then, my lord, your lordship will find, see the flavor of this order, my lord, before I go straight, my lord. See 101, para 6. JSW alleges that immediately after the launch of decorative paints, Asian Paints has started pressurizing dealers who had agreed to stock and display decorative paints manufactured by JSW. 101 bottom line. Third line, Asian Paints in para 8, 6 now. Asian Paints is targeting dealers, distributors and retailers, partnering with JSW, directing them to stop dealing with JSW, stopping supplies to those dealers or dropping services. Idea is basically twisting the arm of those dealers. Then my lordship will find, kindly for a minute turn to 102. 102, my lord, C8. Instances in the state of Karnataka. Several dealers appointed by JSW in Karnataka. Although JSW provided necessary signage and promotional material, dealers were compelled to
Mr.
remove all signages.
Please, where is the discussion regarding discussion of that misuse of dominant position?
All right.
Where is
will
that
not-
discussion? Please come directly in that.
Yes, straight away, Lord. Your Lordship will find, after the DG investigation, your Lordship will find at para 67, page 140.
Yes.
Your Lordship will find it's a very long order at 140 bottom. The commission, in the facts and circumstances of the case and based on evidence on record, notes that the investigation has returned a finding, that is the DG, that the reduction in credit limit in almost all cases of dealers would be necessitated on account of business consideration, either due to reduction in offtake by the dealer or on account of unpaid accumulated overdues, which is stated to be as per laid down policy of Asian Paint. DG found that the actions are stated to be based on objective criteria and uniformly applicable practice of Asian Paints to protect the business interest. In the absence of concrete evidence on record, the Commission observes that the act of reduction in credit limit or stoppage of service of orders placed could not be on account of alleged business association of dealers with the competitor. The informant has not been able to substantiate otherwise. Thus, the Commission, basis on material available on record, that is not as per the report, notes that there is no concrete evidence of alleged restraint.
This was a situation, finding recorded in that situation.
Correct.
So that was considered in the context of
Of what is found by the DG.
context of an enterprises or group under section 4.
Correct.
The word which is used is conduct of an enterprise or group under section 4.
Correct.
So
So my
enterprise
conduct.
is created in this vis-a-vis,
So
one
Milord,
side or other side.
so my conduct, Milord, was examined in the first matter.
Yes.
And the DG gave a report that the allegation, I'm putting it like a layman, Milord. DG gave a report that.
Mr. Rohatgi is a layman, we cannot accept this.
No. Milord, in layman terms, it will be this, that the DG found that I was not twisting the arm of those dealers who were dealing with this man. That is the essence of this whole case.
That was in the year 2022.
Correct? Now their argument is, yes, no. To that the answer is, they themselves say that market conditions are identical. Then what's the difference? See para 90.
That cannot be an argument.
They say,
This inquiry conducted on a complaint of JSW
Yes.
will not give you a certificate that you are the fair and everything, you are not giving any.
You're also
complaint.
right. I may be fair.
Future, no such complaint at all by any.
I'm not saying, Lord. I am saying if it is similar, you must give importance to 2A. That's all I'm saying.
That is not Mr.
I am not saying there is a bar.
Call sir. Just call sir.
Can I just show one more thing?
Yes.
Just kindly turn, Milord, for 1 second
Huh.
to para 19. Just turn, Milord, to 19 of the old one.
Para 19 of.
Yeah, I just show you.
Para 19 of
188.
180.
188.
188, sir.
Yeah. para 19. Now see, my lord, this is in the current order. Para 19, last 4 lines.
Consideration of dominion. The informant has submitted that the
That
sense of
says the market
condition have not been
conditions have not changed. It's their own case. The last 2 years to today has made no difference. Because 2 years was taken, my lord, by the DG. If there is no difference, it is the same.
changed.
I am not being unfair today or I was
Thank you.
fair.
Thank you, you understand. Yes, Mr.
Submission
Paul
for your
sir.
lordship's kind consideration. Our submission is not that once an inquiry is done, after that, and I'm exonerated, I can never ever be inquired on the allegation. That's not the argument. The argument is there is a fundamentals difference between 26.1 and 26.2a. 26.2a, pursuant to the Competition Committee review, was an amendment added in 2023 to say that for purposes of expedience and so that there are no unnecessary repetition or harassment, you can't have the same complaints going on and on. As far as 26.1 is concerned, there are already judgments of your lordships from 2010 onward saying that at that stage, when an opinion is formed by the commission and then a notice is given to the Director General, your right is not to be heard at that stage. No replies to be given. That's after the Director
That is-
General's report comes. You can do no difficulty. That's there. Then comes 26.2a. Now, what is 26.2a? 26.2a is a jurisdictional threshold argument. The argument is that I cannot be today again subjected to inquiry, which I say is on the same facts. Surely for this, you will at least hear me in a reply and give a reasoned order. The impugned order says I need to only give reasons under 26.2a. If I close the inquiry, I don't need to give reasons if I continue with the inquiry. A, you're reading into the statute what is not contained therein. My case is not that I have this absolute impunity, no one can look into me, but surely at a 26.2a stage, you will hear me that the case is the same and should not be gone ahead with.
If 2023, this was an intent of the legislature that you must require to look into that, and then 2-3 things were not required to be used in this. Number one,
Yes.
they have to specify this, that in that situation, if that has been done, then the competition commission may give an opportunity. That is not there. Number two, you use the word whatever, the commission may not inquire.
Yes.
The word which is used is may not inquire.
Right.
So that is into agreement referred to in section 3. So what is agreement referred to in section 3? So this may not inquire referable to an agreement in section 3. So
I'm not.
Also, this is not like
I'm
this.
not for a minute,
It's
my
not
lord,
an
saying,
intention
I'm
of the
not for a
legislature.
minute, I'm not for a minute saying that your lordship, the words used are may not. All that I'm saying is surely a party at a 26.2a is entitled to point out that the earlier complaint and this complaint are identical and give reasons for proceeding. Because my market reputation, my market reputation is at stake, public perception is at stake, damage is being done to me, wide-ranging
No, it is
inquiries
not
are.
like this. Also, we will discuss
Malaj,
again.
may I only say one thing?
We will discuss again with you. We have no problem in discussion with the advocate, sir. You kindly see why the word may not use has been used.
Yes.
Why the word may not has been used?
Right.
The court, they can say may inquire.
Right. Right.
So they have used the word may not inquire.
Right. Right.
So intent of legislature was that if the discretion which is vested with the DG, and if they are having an information to that effect, then in that situation, if the situation as arose as with an agreement to an enterprises and as specified in clause 4, then in that situation you may not go into.
Right.
But if it is not,
But my lord, there is a fundamental difference between
No,
26.1 and 2a.
No, sorry.
26.1 is information.
No, sorry, sir.
Manoj, can I just complete
We are not
this?
in agreement. Now we have understand everything.
Manoj, may I just complete this?
Now we have understand everything.
26.1, you receive an information for the first time. Thus, the Supreme Court says that at that stage you formed an opinion, let it go ahead. Today, we are dealing with an order which relies on the JSW order for market, for dominance, but when it comes to abuse, it says I'm ordering an inquiry. Surely you can, Manoj, if it is to be relied on, then you will deal with the abuse part also. Manoj, surely this requires
Sorry,
the
sir.
JSW order.
Sorry,
There's
sir.
some reason.
This is not a case.
All that I'm saying is, Manoj, keep this in mind. Manoj, keep this in mind. That 26.2a is an order which does give a right to a party to not to be harassed again and
Now let
again.
us understand where you have raised this point before the High Court.
Malas, we have right to said we
Now
want
let
to
us
hear.
understand where you raised this point
No,
before the High Court.
we say it's a jurisdictional issue, it's a threshold
No,
jurisdictional
it's
issue.
not threshold, sir.
Malas, I
Sorry.
tell your lordship, why is it a
Sir,
threshold
please,
issue?
now this is not English.
Can I just make one submission, my lords? I surely have a right if I'm being subjected to.
No right by this language, sir. By this language, no right.
Right to what?
No, sir.
Right to at least hear me that the two allegations are the same.
This is completely on the issue of discretion of the
Manoj-
DG, nothing more.
Manoj, may I with respect say, please do
Nothing more,
not
sir.
vest, please do not vest with the DG a power which the
Thank you.
legislature
After
did not
the-
contemplate. Manoj, just one thing, one last thing. One last thing. I'm sorry, I'm
Certainly,
troubling
sir.
your lordships.
No, it's not a question of troubling. Yes,
Manoj,
you can put your case in your.
Manoj, the impugned order interprets 26(2)(a) to say that if you're closing an inquiry, give reasons. If you're continuing with it, don't give reasons. So it selectively reads reasons into 26(2)(a) for one purpose and not for the other purpose. Where does the legislature provide for it? It clearly says in 26(2)(a), that is what I showed, that reasons have to be given. My lord, if I were to accept this argument of the respondents, the interpretation
No, it
they're
is not a
giving,
question. You see, the reason is in the order of the DG, they analyze the facts and record an opinion prima facie. You see the word which is used is, we will show you that
Has to
prima
be
facie, you kindly see this.
Has to be permanent.
One kindly come to 188, sir.
Otherwise your validity
Come to
statute.
188, sir. No, this is. Just I will let you know. 41, 42, 43. Come to 53. Kindly see 53. In the light of the above analysis, the commission is of the opinion that the prima facie case in contravention of the
I'm sorry, my lord, where are your lordships reading? My lord?
I am
Paragraph-
96, sir. In this case, on the basis of this complaint.
Para 53, yes, my lord.
Yes, sir.
196.
Yes, my lords, I have that. I'm very grateful, my lords.
You kindly read this paragraph.
Yes. In
And
the-
therefore, this violation of section, contravention of provision of 42A1 and 42C, that may be looked into on the facts. So the facts for this would be different. This cannot be similar.
Manas,
Sorry,
in
sir.
the Manas, may I with
Thank you,
respect
sir.
say, how
Please.
can it be that reasons are
Thank you,
given
sir.
for
Please.
closing and reasons are not given for continuing?
Fair enough.
May I then,
Thank
Manas,
you.
Manas, may I then be permitted
No,
to withdraw this petition, Manas?
No. This is 1 hour of 45 minutes of arguments. That's not fair, Manus. It's not fair. No, Manus, with respect. Your lordship is very patient, very kind, 45 minutes.
Right, my lord.
Your lordship has been patient beyond the call of duty.
Just-
Your lordship knows that.
We always try to be patient.
That's
to
true,
this
Manus.
side.
Just see what signal it sends to the client. Take your full chances, then withdraw. Take your full chances, then withdraw.
Sir,
Then come up again on something else.
Dr. Singhvi. Dr.
That's not
Singhvi.
fair, but that's a
Just
regular
please-
justice process. You're
just
very
please-
kind and we are trying to abuse it. That's not fair.
Please try to understand, Dr. Singhvi. Suppose they withdraw. What would be the consequence?
Well, suppose lordship
No,
dismisses
suppose they
Tripati
withdraw after
under
this
Kunya
argument.
Ahmed,
We are not
under
saying,
Kunya-
we are only saying we are not
True,
inclined
but
to
if your
entertain this
lordship
SLP.
dismisses also under Kunya Ahmed, this is not binding precedent. If your lordship dismisses under Kunya Ahmed, this is not binding precedent.
Mr. Singhvi.
Well, I am on the
We are not,
conduct.
every time we have not to interpret
Ultimately,
everything, sir.
ultimately, it's your lordship discretion.
Yes, sir, fine.
But Manus,
Ligge.
your lordship has
Withdraw.
been extremely patient.
Ligge.
After 45 minutes, don't allow a withdrawal.
Your lordships had done it earlier and my learned friend
Ligge.
had also prayed for the same belief in
Mr. Call, sir, you tell us now. If you will say
No,
to
that's all right.
here, he will not hear.
I'm beseeching your
Here,
lordships for-
here he will not hear.
I'm
After the,
beseeching and
outside the
requesting
court, he will hear you.
beseeching your lordships
One
for-
last thing in a lighter vein. Now the case is over. He has withdrawn. In a lighter vein, Manus. I was telling my learning friend, your lordships bent over backwards to try to persuade first Mr. Rohgi and then Mr. Kaul. Your lordship forgot that he's paid to persuade you. He'll never be persuaded by your lordships. He'll never be persuaded by your
You're
lordship.
very often persuaded by your lordship.
So don't try to persuade your lordship.
The
Remember the
same-
bar here. Don't try to
Sir,
persuade.
the same thing is applicable on every advocate.
To me, of course it is. So your lordship's patience
No.
cannot extend to the point of
Actually,
persuading us.
He can tell you everything. Every time we read by our own.
I know that.
But
Everybody
when we
knows that.
discuss here, that's a different phase. In discussion,
Your-
comes a different phase. Then we apply this. And once we understand, then certainly you are right.
Now your lordship is allowed withdrawal, But Manoj, it's such extensive arguments, your lordship doesn't normally do it. That's all I'm saying.
After arguing for some time, learned senior counsel appearing on behalf of the petitioner seeks permission to withdraw. This has to be accordingly dismissed as withdrawn.
Very grateful.
Quickly apply.
Very
Thank you.